I mean, essentially, we were instructed by our client to draft a budget on a case. Having drafted the budget, it appears that the budget wasn't filed with the court in time and in accordance with the civil procedure rules. That meant that under civil procedure rule 3.14, the claimant was limited to court fees only. So essentially what that meant is that the solicitors then had to run the case until conclusion, knowing that they wouldn't get paid any of their costs, but they still had to do the job. The case then came to us following conclusion of the case by reference to acceptance of a Part 36 offer. We prepared a bill, and our knowledge of the rules in the case meant that we prepared a bill for the costs that the solicitors had incurred up to that breach, and thereafter the court fees. The defendant's position was that essentially we weren't entitled to any costs, because by us accepting their offer, it was a contractual agreement and we were only entitled to court fees only. Having run the case to a provisional assessment, we were successful. The defendants applied to orally review that decision and they were successful, and we took the decision that the judge was wrong and that we should appeal. Having appealed the matter, and the matter came before Her Honour Judge Walden Smith in Norwich, we were successful on the case in recovering our solicitors' costs. So that's a brief overview of the case. It involved essentially two issues: the consideration of a detailed consideration of a Part 36 offer made by the defendants and the implications of that, and also what was meant by the court restricting the claimants to costs under CPR 3.14, whether or not that applied to the future costs after the breach or all costs, including the costs up to and including that breach. So it was quite an important case, and what perhaps a lot of solicitors don't understand is that if they fall foul of that rule and their costs are limited to court fees only, we feel that applies to future costs only and not the entire cost of the case. So that's effectively what we appealed and were successful on. So it was quite an important decision, not only from a financial point of view for our clients, but it was also a little bit of ammunition to our clients, knowing that if they do fall foul of this rule in the future, that it doesn't impact on the entirety of their costs, but only the future costs. I think from a methodology point of view, we needed to consider how we felt that the judge had erred or fell into error making this decision. That was one of the things that was quite important to consider. The problem with appeals is that the test on appeal is very, very strict, and it involves a detailed consideration of whether or not any appeal has a real prospect of success, or if there is any other compelling reason as to why the appeal should be heard. So the test is quite strict. And for example, if a judge has exercised his or her discretion in a certain way, that might not always get over that hurdle of permission to appeal. So I think that's certainly one thing that we needed to consider, and we needed to consider if we felt that the error made was such that it passed that permission to appeal test. There was another consideration, which was a financial consideration as well, because although we were limited by reference to the judge's decision to court fees, they equated to £9,000. The court had already assessed the bill at £33,000, so there was a financial implication there of the difference between the two figures, and whether or not our client thought it reasonable and proportionate to proceed with any appeal. And bearing in mind the financial implications, if they were to lose, they would have to pay not only further court fees, our barristers' fees, but also the potential for any adverse costs payable to the defendant. So there was that impact as well. The third important point was the impact on future cases as well, because obviously it isn't just about this one case. It's a a decision that helps us moving forward and advising our clients on other cases in which they fall foul of this rule also, because we have a detailed decision which backs up what we were saying as to the implications of a acceptance of a Part 36 offer in these terms, but also the implications of a failure to comply with CPR 3.14 and what that means for solicitors, in that they know that any failure to comply with that rule means that they're only liable, or they wouldn't be able to recover future costs, and that their costs incurred up to that point are protected. I think it was difficult in that, in relation to the impact of CPR 3.14, we don't have any higher court decisions or authorities to rely on, which is kind of surprising that we don't. And what I mean by that is that not many solicitors are aware of the fact that if they fall foul of CPR 3.13 in failing to file a budget within the prescribed time limits as ordered by the court, that impact affects their future costs only. And that's certainly our understanding of the rules and the implications of that rule. So that's quite an important point. Certainly in relation to Part 36, there's a hell of a lot of case law out there as to the impact of Part 36 and acceptance of Part 36 offers. But the other issue on this matter was when the defendants made their Part 36, they referenced how they would deal with costs, and that was by reference to the order restricting us to court fees. So the defendant's position was that whilst it was a Part 36 offer, it was quite clearly set out that we were only entitled to court fees as per the order restricting us to court fees. But our counter argument was that the court fee restriction only applied to future costs, and quite happily the judge went our way in relation to that point also. So it wasn't an overly difficult case from that point of view, but there was a lot of research, and it wasn't just one singular point. There were 2 points which were conjoined. One thing that we do at County Well is we have monthly meetings in which we discuss these cases, so that we've got other fee earners' involvement, which also helps considerably if you've got other cost professionals backing you up and agreeing with your opinion on these cases. Because I think from an early stage, we thought that the judge had got it wrong. And we felt that it was important to appeal this decision, not only from a financial point of view, but from a point of view of protecting our client in relation to their position and their costs. But I think we do have this process where we have meetings within county with all fee earners, and we put these discussions out to the table so that everybody can have an impact and give their opinion, which always helps. The other issue is that it fell over the Christmas period, this appeal process. I think the decision was the second week in December, and obviously we had to appeal by the 3rd of January 2023. So we needed to make sure that as a firm we were available to discuss these time limits and discuss the decision with our client over the Christmas period, so that they had a full understanding of their liabilities and the potential problems that we faced, so that they could make a decision as to whether or not they wish to appeal or not. So I think from that point of view, certainly the interaction with not only our client but other cost professionals within county certainly helped. I think with this particular client, we've got a long-standing relationship with them. They trust what we say. We've been getting work off them for a number of years. We do all the cost work. We do a lot of work for them, unpaid training. And I think the light at the end of the tunnel was effectively getting a decision in which we felt that was correct. I mean, obviously there's a financial implication. There's a financial implication for our client, but there's also a financial implication for county, because after the original decision, we don't get paid a penny. We lose our budget fees, we lose our bill fees, we lose all the costs of the assessment. So there was a financial implication there, but mainly I think it's about getting a decision that's right, and certainly right for our client. Judges, like most of us, they get decisions wrong, and we just felt that this was one decision in which it was clearly wrong, and clearly it was a case that we were able to appeal and get over the quite strict hurdle of permission to appeal. And I think it was just one of those cases where you sit back and you can't see any reason why potentially you wouldn't win on an appeal, and that was borne out in the end.
So
I think from an early stage, we felt that there wasn't really any weaknesses in our case. I think litigation is always risky, and you can never say that 100% you're going to be successful. But I think from an early stage, following discussions within the county group, we all formed the view that this was a case that was incorrectly decided, and would potentially, we would have quite a high, if we were to appeal it, we would be successful. I think once we'd then gone to our counsel who dealt with the case, instructed him, and he was of the same opinion, I think that effectively backs up to our client what we've said all along. But I presume the only potential weakness was that litigation is risky, and there's never a surefire winner. But this was as close to it as possible. And I think as the case progressed, we obtained permission to appeal on paper, which is always quite a telling point if you obtain permission to appeal that way. So it made it slightly easier moving forward as well. From an appeal point of view, I think the year earlier we'd had a number of appeals in which we'd been successful. The timeframes when you apply to appeal are quite strict, so you have 21 days to lodge any appeal documentation. You then have to obtain transcripts and lodge bundles in accordance with CPR 52. So I think from that point of view, and having the knowledge of dealing with appeals, that certainly helped. Again, the monthly meetings that we have with all the fee earners at county help, because these issues do come up quite a lot, and we're able to form an opinion within those meetings, having discussed it. We also circulate details of case law, which may help fee earners in their day-to-day workings. So I think from that point of view, we were well versed in dealing with these issues, certainly the appeal issues, and certainly the two issues that came up in this particular case, because we've always been of the view that when you look at the sanction under CPR 3.14, that can only apply to future costs. It can't apply to incurred costs. So those are protected. And certainly on the Part 36 point, we formed the view that that was our stronger point, and that the acceptance of the Part 36 created a liability for our costs and not the court fees only. So yeah, I think within the county family, we are able to discuss these cases on a monthly basis in the meetings that we have, and not just these cases, but all cases that we have, and circulate the literature to our fee earners to enable them to fight for all our clients. I think, as mentioned, we'd had a number of appeals the previous year, so that certainly helped. The procedure in relation to appealing, as mentioned, there are strict time limits which you have to adhere to. But if you're not able to adhere to those time limits, we know that you need to apply for extensions so that you're not breaching any orders. And we certainly have a lot of experience in relation to Part 36 offers. We've run quite a lot of data breach cases which have settled by reference to Part 36 offers. So I think that knowledge has certainly helped us moving forward. In relation to the other case of the impact of 3.14, CPR 3.14, as I mentioned, there is a distinct lack of higher court authority on that particular point, which is surprising, but I'm hopeful that this decision will certainly serve to help our clients, not just this particular client, but all our clients when they fall foul of this rule.
Amazing.
I think this probably comes down to the relationship that we enjoy with this client. As mentioned, we've acted for this client for quite a considerable amount of time. They value our opinion, they value our input. And on this particular case, we were quite adamant that this was a case that we would be successful on appeal. And they backed us. And I think that's quite important. If you build up that rapport and that relationship with a client, that they trust what you say, that certainly helps. And I think it helped on this particular case. So I think it's important to have that relationship with a client, to be available, 24/7 to discuss issues that the client might have. It may be that they come up with a reason why they don't think we should appeal, and we've got to appease them. We've got to be available to speak to them, and we enjoy that relationship with this client, but on all our clients as well. And I think we enjoy quite a close-knit community at county as well. So if we needed to discuss with other cost lawyers or cost draftsmen within our firm, if you're having a bit of a wobble on a particular issue, if you discuss it with the county team, that helps if they're on the same sheet as you. And I think appeals are notoriously difficult, but our win rate is extremely high on them. So I think we're quite proud of that as well, and it certainly backs up what we say to our client.